Hi everyone, in this video I am going to explain to you about unwritten law. As I have explained to you previously, unwritten law is the second type of sources of law in Malaysia. Apart from written law, unwritten law is also important in the Malaysian legal system. Unwritten laws are the laws which are not made by our legislatures and not found in the federal or states' constitutions. Unwritten laws are divided further into four: English law, judicial decisions, customary law, and Islamic law. The English law that being applied is divided into two. They are the common law and law of equity. Common law is the judge-made law, while the law of equity is to reduce the harshness of the common law. This is because sometimes the common law is too rigid and provides unsatisfactory remedy or no remedy at all to the claimant. English law is applied in Malaysia by virtue of Section 3 Clause 1 of the Civil Law Act 1956. According to this section, the application of English law in Malaysia is divided into three. 1. In Peninsular Malaysia, the English law which is applied are those which were administered and enforceable in England as on 7th April 1956. As for Sabah, the English law which were administered and enforceable in England as at 1st December 1951, and for Sarawak, the one which were enforceable in England as at 12th December 1949. The English law is only applied if there is a loophole in the Malaysian legal system, meaning the English law is only to be applied if there is no law in Malaysia governing on certain issues or matters that arise. Secondly, the law must be suitable to the local people and circumstances. This means the ruling in the judgment of the previous judges in the previous decided cases become the sources of law. Those decisions being referred to and followed by the later courts if the cases are similar in the facts and circumstances. The practice of referring to the past judicial decisions comes from the doctrine of judicial precedent or stare decisis. This doctrine requires the judges to refer to the previous case law as a precedent or as a binding authority in making their decisions. The judges are bound to follow that judicial precedent. In short, judicial precedence means the previous decisions which are binding upon the later cases. Customary law are also recognized as part of the unwritten laws. They are not enacted or made by the legislatures. They come from the norms, behaviors, practices, and beliefs which are carried out by one generation to another generation. They are historically developed from the ancient time among each ethnic group. The customary law is only recognized by the court if it meets 4 conditions as follows. These are among the customary laws which are applicable in Malaysia. Alright, this is the summary for unwritten law. We have 4 kinds of sources of law which are categorized as unwritten law. Thank you for watching this video and have a nice day.